Afternoon to all of you, the members of our viewing audience. On behalf of the members of our selection commission, I welcome and thank you for joining us and for your support for the work of our commission. This is our official meeting and it is being broadcasted by the High Council of Justice. The purpose of our meeting today is to approve the 4 candidates we have chosen to interview as part of the competition our commission opened to fill a vacancy on the High Qualification Commission of Judges of Ukraine, the HQCJ. Please allow me to do a roll call and to introduce the members of our commission to you. My name is Ted Zarzechny, and I'm a retired federal court judge from Canada. The Ukrainian members of our commission are Justice Ivan Mischenko, our current chairman and a member of the Supreme Court of Ukraine. Because of commitments, he is unable to participate in today's official meeting. He will join us later in the day. The other Ukrainian members of our commission are Judge Yevgen Mizentsev and Judge Sergei Verlanov. These are judges of the Court of Appeal of Kiev. The other international members of our commission are Justice Stephen Markman, retired Chief Justice of Michigan, the state of Michigan of the United States of America. And lastly, Robert Broekhuizen, a senior lawyer and retired anti-corruption prosecutor from the Netherlands. As you are all appearing on our YouTube broadcast, colleagues, I declare that this is a properly constituted meeting and we have a sufficient number of members to constitute a quorum under the law. Let me now begin with the business of our meeting today. First of all, I have been requested to chair this meeting because of the unavailability of our chairman, Mr. Judge Mischenko. And so I propose a resolution appointing me as chair of the meeting and as well approving the agenda that we have prepared for the meeting today. All in favor, commission members, for that appointment as chairman and for the approval of the agenda, please raise your hands. All right, Robert? Yes, thank you. Resolution approved. The next resolution is the substance primarily of our meeting, and it is to take our decision respecting approval of the list of candidates invited for the interview. And colleagues, after much discussion and review of the materials we have before us, I can report to our viewers that we have a resolution to approve the following list of candidates to proceed to stage 2, the interview stage of our selection process, and they are as follows. Retired Justice Ihor Kuznir, Judge Victoria Holub, Judge Oksana Wozniuk, and Judge Yaroslava Kravchenko. Colleagues, all in favor of approving those for the next stage of our competition, please raise your hands.
Yevgen, your hand.
All right. Yevgen, ladies and gentlemen and colleagues, has recused himself because of his association with Ihor Kuznir. So we accept his recusal from the actual vote. So with that, colleagues, I am pleased to announce that those four candidates that I have named have now been admitted to stage two, the interview stage of our competition. Before I present the resolution to end this meeting on behalf of the members of our commission, I wish to thank all judges who have applied to fill this vacancy on the HQCJ. Our commission extends to you and wishes you continued success in your judicial careers. And we exercise the hope that you will continue to serve the people of Ukraine as judges, competently and with integrity. Viewers, we will continue this broadcast shortly to begin the interview of the first two of the candidates approved for the interview stage. I now present, colleagues, a resolution approving the end of this official meeting. All in favor, please raise your hands.
Connection.
Thank you very much, Judge Mizentsev. With that, ladies and gentlemen, we are adjourned to reconvene to begin for today. First of all, if we have any difficulty with the transmission of our interview process, or there is an interruption with our link, whether with you or with each other, we will do our best to correct the problem. We will reconnect with you if at all possible. So please stand by should something like that occur. If we have any problems reconnecting with you, then we will contact you and we will reschedule the remainder of our interview with you. And those circumstances, of course, are because of the situation currently in Ukraine. The progress of our interview will begin by me providing a brief introduction of you to our viewing audience. That will be followed by an opportunity, Mr. Kushner, for you to provide in 2 or 3 minutes your opening statement to us. That may include your motivation for seeking appointment to the High Qualification Commission, and I may simply call it the Qualification Commission, and as well any other information that you wish to share with us before your interview begins. Following your opening remarks, we will then begin the round of questioning. I should mention in that regard that 2 of our members, Justice Ivan Mischenko, the chairman of our commission, together with Judge Yevgen Mizentsev, have recused themselves from participation in your interviews. That is because of a personal acquaintance that they have with you. The one was a colleague of yours on the Supreme Court of Ukraine, and the other one serves with you on the defense militia of Kiev. So they have recused themselves from participation in your interviews. What we will do in terms of process is I will begin with a question or 2 of you that I have, and then we will alternate. We will then invite Judge Verlanov to present questions, and then that will be followed by Justice Stephen Markman and Mr. Robert Druckheisen. We are the international members of the commission. There may be 2 or 3 rounds of questions that we have for you until we receive all of the information that we feel is necessary based upon the documentation that you have provided and our own research. So once the process of interview has been concluded, we will adjourn the interview for an internal discussion. We will terminate your role and involvement in this matter, and we will thank you for your participation. So that is the protocol that we intend to follow. So with that, for the benefit of our viewing audience, let me simply introduce Igor Kushner. Judge Kushner is 47 years of age. In terms of his professional background, he has a total work experience in the law of 20 years and 4 months as of the date of his application, and he has experience as a judge for 16 years and 4 months. Mr. Kushner has higher legal education from the Yaroslav Mundry National Law Academy of Ukraine, achieved a specialty designation in law, and he qualified early on in his career as a lawyer and received a diploma. In terms of briefly his work history, and you may share more of that with our audience, Mr. Kushner. He began his legal career as a prosecutor in the Department of Chernihiv region. He received a number of promotions in that role and responsibility, ultimately being senior prosecutor of the department. He worked as an assistant judge to the Economic Court of Chernihiv, and on May 18th, 2004, at the age of approximately 27 or 28 years, if my mathematics is correct, Judge Kushner, you were appointed a judge of the Economic Court of the Chernihiv region, a position in which you served, as I calculated, for 13 years. Subsequently, on November 17th, 2017, you were appointed a judge of the Supreme Court of Ukraine in the Commercial Court of Cassation, a position that you occupied until September 15th, 2020, when there was accepted your voluntary resignation from the court. So with that introduction, Mr. Kushner, I invite you please to correct any mistakes that I may have made in introducing you, but as well to provide us with your opening statement. I turn the floor over to you, sir.
Thank you for this opportunity. Yes, really, my career is over 20 years of purely legal experience. Why have I applied for this competition, and why do I believe that my experience can be relevant for this position? As it is well known, the HQCJ is dealing with appointment of judges in 4 jurisdictions, including administrative, commercial, criminal, and civil, and is dealing with appointment of judges to all 3 instances, including first instance, appellate, and cassation instances. I started my professional career in the prosecutor's office, where my main function was supervision of a compliance with laws. But still, as a prosecutor, I was participating in criminal hearings in courts. After that, I worked in the regional prosecutor's office for 3 years, where I was working for 1 year in the supervision department, and for 2 years I was a prosecutor in the Court of Appeal of Chernihiv region. So my first experience was related to criminal judiciary. After that, as you've correctly pointed out, for 13 years I worked in the Commercial Court of Chernihiv region. Initially, for the first 4 years in this court, I worked in the sphere where administrative courts are working now. That is the taxation panel, where we were considering taxation complaints, complaints with funds, and many other cases related to state governance. And I started after that considering, our panel started considering cases related to land relations and environmental disputes, as well as disputes that were allocated to us were based on the general allocation system. After that, I took part in the competition, and I worked in the Supreme Court. And there I was basically also working in the panel that was responsible for consideration of cases related to land relationships, real estate issues. So I would like to emphasize that I used to work in the third instances, and basically I worked with 3 jurisdictions, except for the civil jurisdiction that is related to labor law or family law. I did not work in this sphere, in fact. But I worked with criminals, part of the civil law that is very similar, close to the commercial law and administrative cases, and I had experience with these 3 spheres, and I believe that this experience can be useful while performing functions of the member of the HQCJ. Thank you.
Thank you very much for your introduction, Mr. Kushner. I hope you are not distracted by the fact that as you are speaking and as of course we begin the questioning process, uh, we are making notes of what is being said. So if we happen to appear not to be giving you our attention, I can assure you that we can both write and hear at the same time. And we want to make sure that we properly record the exchanges that we have with you. I'm going to begin with I think, a rather obvious question of you. You retired from the Supreme Court of Ukraine after only 3 years of service on that court. I find that somewhat unusual. That is, of course, a position insofar as the courts of Ukraine and indeed the courts of many countries is concerned, is a senior court, the highest court, if you want to use that term, of your country, as it is in our country. And it is a very responsible position. I'm presuming that you considered it very carefully before you applied to be appointed to the Supreme Court. I presume that you made a point of understanding the nature of the work of the court, the responsibilities of the court, and as I say, the importance of the cases that come before the court. Now, with all of those presumptions, why did you resign your position, this very important position on the court, after only 3 years of service?
I think that the main reason was re-estimation of my attitude towards the reform and towards the creation of the new court. For a long time, people were saying that Ukraine cannot be rebuilt based on its Soviet past, that for a long period of time, Ukraine was stuck. After invasion of Russia in 2014, it seemed that Russia gave it an impetus for the society and the state to reevaluate all of this, to how to properly phrase that, to unite public authorities, to unite the civil society in order to move to European models. And all of these competitions, primarily to the Supreme Court, were competitions to the police, to the prosecutor's office. It seemed that there would be support from people and from the legal community, but basically it did not happen in reality. Maybe you found my article. It was called "Betrayal is Sold Better Than Victory." That is the peculiarity that is quite often described. And people are always saying that, I don't know whether it's a consequence of the Russian past or with the Soviet past. People pathologically hate the government in any form and do not trust any reforms. And since the very beginning, people are looking for some negative aspects in every reform, and they are trying to find all the negative aspects in order to confirm their perceptions. And establishment of the Supreme Court happened like what? It happened with amendments to the Commercial Procedure Code. The entire chapter on cassation was amended. We were discussing each phrase with Dave, how to properly phrase it, how to have this composition of the court. And since they were beginning, they were making fun of how we are drafting rulings about the composition of the court, etc. And the further it went and the closer it became to the election process in 2019, they started accusing us that we are political project of the president. And they were accusing us of going to the office of the president, taking oaths, and that's why we got these positions. And I was always amazed by that, given that I was initially the judge in Chernihiv region, and like was the gap between Chernihiv region and the office of the president. It heightened and intensified after the elections. Then there was this law that decreased us to 100 judges and decreased the salary to the level of the appellate instance. And only the decision of the Constitutional Court brought all of that back. And maybe there was this euphoria, initial euphoria resulted in demotivation, so to say. And maybe I had burnout, probably. That became the reason for that.
Well, Mr. Kushner, it seems to me that some of those circumstances that you have just explained to us were circumstances that existed before you were appointed to the Supreme Court. I have reviewed statistics from public surveys, and yes, it does appear, unfortunately, that the Ukrainian public has some reservations about how they are being served by judges. But nevertheless, knowing that, having been a judge, no doubt being aware of some public criticism, as you have just explained to us, with respect to the Supreme Court and all courts of Ukraine, nevertheless, you applied for the Supreme Court. You knew what you were getting into. And my question really is out of a concern of your dedication to the work of the judiciary and your dedication to the work of the Supreme Court. Why did you not continue to do the work of the Supreme Court and attempt to persuade people through your work and the work of your court that there was good reason to have confidence in the integrity of the Supreme Court and its members? Do you not agree?
For the first 3 years, I was doing that, especially for the first year and a half, I was proving that. Because the first year and a half were the most intense in terms of workload. When I was resigning, the workload was not that significant. But for the first year and a half, when we were considering remaining cases from the previous Supreme Court of Ukraine, higher commercial courts, initially we heard one figures, but the remaining amount of cases was almost twice as big. And our cassation commercial court got the indicator of 90% of considering remaining cases at the end of the first year. No other court provided this achievement. I understand that the Civil Administrative Court had more cases, but we were showing that through our work. So I do not agree with you that I did not want to do that. I was showing through my work as much as I could, especially during the first year. I exceeded terms during the peak moment from May to June only under some cases, when I had lots of cases remaining from the Supreme Court of Ukraine and higher commercial courts to the consideration of the new cases for the courts of appeal. And after that, I never violated terms for the consideration of any cases. Apart from cases with suspension, because it was objectively impossible to consider them within 2 months.
All right, we seem to be on the same page in terms of this issue, Mr. Kushner. I am sure you speak now about the workload, and that what I took from your comments is that the workload was extremely heavy, and it contributed to your concern about continuing on the court. But you will be aware, Mr. Kushner, of the extraordinary workload that faces the High Qualification Commission in Ukraine. The last statistics that I have received is that there are close to 2,500 judicial positions to fill. There is the continuing requalification of judges that needs to be accomplished. There are huge vacancies in the courts of appeal of Ukraine. And so there is no question there is a huge and heavy workload on the High Qualification Commission. If you are concerned, and you were concerned about the workload on the Supreme Court, and it contributed to your early resignation from the court, how is it that you will then accept the responsibility of doing the heavy workload that the HQCJ faces?
No, the workload was not the reason for my retirement, because back then it decreased as of the moment of retirement as compared to how it was before that. The figures that you are naming, of course, I know them. I read them almost every day. Yesterday, there was a speech by the chairman of the HQCJ and the CJ, but these figures, in my opinion, show why I retired. Like, why do we have so many vacant positions? 1/4 of judges of the Supreme Court are already retired. 58% of judges of the Courts of Appeal are also retired. And did they retire due to age? No, but I know about the workload. I'm not concerned about the workload at all. I could deal with the first year and a half in the Supreme Court, so I can deal with the workload in the HQCJ. The problem was not with the workload. It was more about my reevaluation. Maybe back then we did not evaluate our work properly.
Right, thank you for your answer. My last question is this: from the information both you and our analysts have provided to us, some short 2 years after your resignation from the Supreme Court, you made an application for selection for the position of a member of the High Council of Justice. And the Ethics Council recognized your qualifications, both in terms of integrity and professional competence, and they recommended your appointment to that position. As things turned out, there was an election and you were not successful. However, nevertheless, you completed the review by the Ethics Council. Thereafter, in 2024, the competition to be appointed a member of the Constitutional Court of Ukraine. And we are advised then that you filed an application for your voluntary termination of your participation in that competition. And then in 2024, you made your first application to be appointed a member of the HQCJ. So we have your early retirement after 3 years from the Supreme Court. We have your application to be a member of the High Council of Justice, not successful. We have your application then to participate in the competition for the Constitutional Court of Ukraine, and you withdrew voluntarily from that competition. And then this is now your second um, application for appointment to the HQCJ. And really, my question is this. I find those circumstances will raise the question in my mind, and as well other people's mind, at your level of commitment to this competition, your level of commitment to the High Qualification Commission of Judges. It appears that you have been interested in a number of other positions. Is it just that you're looking for a job, or what can you tell me about these circumstances?
Thank you. Thank you for your question. So first of all, you were rightly mentioning that first time I applied for the position in the HQCJ after 2 years, my retirement. So why is it so? Why it's 2 years? 2 years is quite enough period to have some rest after 3 years of permanent work without any pauses at all. So to reassess, to reboot yourself, and only then, after having some rest, after feeling that I have some desire to work further, and I applied for the position. When you mentioned that like different searches of work, no, I would not say it's because, you know, work as an HQCJ or HQCJ member, it's like they overlapping. It's to vet candidates for the positions of judges. That's the issue of disciplinary responsibility. Before it was considered under responsibility of the HQCJ, now it's under responsibility of HQCJ. But in terms of appointing of judges and disciplinary responsibility, so actually the work of HQCJ and HQCJ are overlapping, just different stages. Again, going back to the Constitutional Court. Constitutional Court very often considers different issues which could be considered as global and theoretical, but actually it was it's known that the best composition of the Constitutional Court, when half of them are theoretical specialists and other half that's practical specialists, practitioners, those who give some practical experience and those who have only theoretical doctrine. So everything is so interconnected. And also take into consideration that I have worked as a judge for 20 years, so as a judge of general jurisdiction. For me, it was an interest, you know, to move to the field where the background and knowledge required to be the same, but the essence of work is a little bit different. So to change a little bit the direction of my work, but generally applying the same knowledge and experience which I gained working as a judge. That was my motivation when I applied for those positions in those competitions. So yeah, I didn't participate in those competitions for the second time. I participated there only once, both regarding the Constitutional Court and HQCJ. Thank you.
Thank you for your answer. Thank you, Mr. Kushner. I'm going to turn over the questioning now to my colleague, Judge Verlanov. And Sergey, if you would begin your questions, please.
Thank you, Ted. So, dear Igor, I will follow up the questions which Ted asked you, and I will base them on your replies. So my question to you is the following. Now, you have provided some figures regarding dismissals of judges, both of the different courts, including appellate courts. So as of now, but to your opinion, what do you think? Why do we have such a high number of dismissals of judges for now? As I've mentioned, so this again, that's the same huge level of distrust, and that's actually That's what we have. So usually, responsibility is brought to judges not to individual approach, not a tailored approach, but automatically any judge is considered to be as a malicious one. So it doesn't matter what they do; they're considered to be as bad judges and malicious ones, and that's all. Okay, thank you. Clear. Let's imagine that you're appointed as a HQCJ member. What would you do in order to restore trust to the judicial system based on the previous information that you provided to us? In order to improve the situation, what would you do? Within the functions of HQCJ, decisions and decision-making process are available for HQCJ members. It's the same as it's for courts, and it's the same as for any authority in the state. And of course, individual behavior and individual conduct of HQCJ members. And again, the same example of the head of the Supreme Court, who actually right now is notorious person, and now reforms of the Supreme Court are being suggested all the time, but actually there's only one person of the as a judge of Supreme Court is mentioned, and that's head of Supreme Court. Thank you. The next question. So you have explained to us that you submitted for different competitions. So in 2022 to the High Council of Justice, then in 2024 you submitted for the position of the judge of the Constitutional Court, and in September 2024 you submitted an application, so a statement for voluntarily withdrawal of your participation from this competition. Can you please explain why you decided to stop your participation in the competition for the position of the Constitutional Court judge? Because I looked at the questions, the number of the questions, and the essence of the questions, and I understood that I'm not going to reply to them, that it's not about vetting, it's actually the borderline questions, and it more looks like some kind of, some other things. And it more looks like abuse of using such questions. If you look at such figures, there are, for example, in different competitions, half of so in the first competition, half of candidates actually stopped their participation before the interviews. And the second in the second competition, there was the same. At the third competition, actually 7 candidates stopped their participation. So maybe these figures speak about something. And at what stage did you submit your letter to stop your participation? I stopped my participation when I received the questionnaire, when I received questions, so specifically personal questions which were focused at my position. So you made a decision to stop your participation. And so the advisory group published the article which was called some kind of Saint Inquisition. So what was, why was this article written about? So why do they do these questions? Okay, thank you. Next question to you. Based on our materials available for our competition commission, we can see that your wife's sister had worked as a prosecutor before 2014 in the city of Sevastopol. That's Halina Volodymyrovna Khramova. Tell me, please, where is she right now? Do you know her whereabouts? And if yes, do you maintain any connections with her? Did your relatives, other relatives, visited her? So I personally, I don't have any contacts. Since 2014, I have not visited nor her, nor Crimea. And what about your relatives? My wife has some calls with her, and my wife visited twice her. So it's her own sister. How I can impact on this situation? So her parents also visited their daughter, this sister of my wife. So all they communicate through messengers. Good, thank you. Thank you for your replies. And that's all from my side. I don't have any questions. Now I give the floor to Robert. Thank you.
That's also Stephen.
Yes,
to you.
yes, thank you, Judge Verlanov. I'll turn now to Justice Stephen Markman, and he may have some questions for you, Mr. Kushner.
Thank you for being here, Judge Kushner. We're all very appreciative of that, and In particular, I'd like to thank you for your efforts in defense of your nation during the course of the present Russian invasion, along with Judge Mizentsev and no doubt many other very fine people. I thank you for those efforts. In your motivation, Judge Kushner, you state that judges must be held to their duties, they must be honest and professional, and they must not be scoundrels in robes. These are all very good sentiments, and they're expressed in one manner or another by many of our applicants. But you've been impatient with the progress of the judicial reform process. You call it endless. How would you make intelligent determinations about who manages to work within their duties, who is honest and professional, and who is not a scoundrel? How do you plan to approach this? What are your thoughts and insights? Your motivation sets forth this critique, but it really doesn't provide too much help, at least to this judge, in understanding how, if you're appointed to the HQCJ, you would distinguish between the kind of people we need on the HQCJ and the kind of people we don't need there.
So first of all, speaking about key criteria, and if we're speaking about judges, assessment of judges, that's to assess their decisions, and not a single one, but many judges, in order many decisions, how a judge substantiates those decisions or not substantiates, so if that's an issue of a conduct or behavior of a judge, inappropriate behavior of a judge, now we have a video recording or general recording of different processes, so we can watch them, video recordings, watch and understand. Or for example, photos could be analyzed. We can watch those, look at those photos and realize how a judge behaves themselves within the process itself. And also information, somehow exists. So also public council of integrity, it works for some purposes. Information is being collected. Maybe there are some recordings made in real life or some evidences in social media. So a range of information could be wide. So usually behavior is recorded by audio or video, and their attitude to their work, that's how they motivate and substantiate their decisions. And the same, that's about some how they're described by their leadership, supervisors, peers, or some other persons. So actually that's described in the law how qualification assessment shall be done. But again, speaking about property, we shall analyze declarations of those candidates and of those persons and the registers. If there is no usage of information of the property, we can check also audio and video recordings. For example, if this person uses some property which they do not declare. So this is the key thing which I can tell you.
Doesn't that kind of oversight take a great deal of time and care and attention? And yet you've already been critical of the process for having been endless. Won't that make the process even more endless?
What other options? What other alternatives? The same as in courts. In courts, you study case files. All parties to the process submit some documents, and you shall study each page, each file. The same as when we consider candidates for the positions of judges. So, if you would like to do your work very well, you need to read and study all the pages of all the files from the first to the last one. And then based on this analysis, you can develop your opinion regarding this candidate, and you will maintain your position based on this evidence of data. There is no other option for HQCJ member, HQCJ member, or a judge, except of studying all files, all documents from the first page to the last. If I understand the question correctly.
Judge Kushner, our process of the selection commission here has been made much lengthier because one of our 16 appointees to the HQCJ has left the HQCJ. Because of that, the work of the HQCJ has been delayed, and we've had to introduce this new selection process because of the departure of one judge from the HQCJ. I guess I'd like to follow up on the questions my two colleagues have already asked you. How can we be comfortable that we are not going to have another vacancy that will require extensive and lengthy efforts by this commission if you are appointed to the HQCJ? I know you've answered that, but can you explain to me just how we can have great confidence that you will not reduce the 16 members to 15 members and require another competition like this one?
Can you please repeat the last several words? I didn't hear. Okay, I have got very well. Your question, yeah, and I fully understand that in comparison with the Supreme Court, actually the HQCJ is a collegial body, and each person there, each member is so valuable as a gold. And actually HQCJ and actually the same as constitutional court, they depend so much on the quorum. And that's, I really understand very well that that's like a short-term work. So that's not a permanent work. That's work for the period of 4 years. So this is the position when you are appointed for the 4 years.
It has to be an extraordinary situation because you've correctly pointed out that the member of the HQCJ left, but many people are raising questions, and there are no doubts that he left not because of the workload. At least based on what I read in the press, in the internet, he left not because of the workload and not because of his unwillingness to work.
Judge Kushner, you have, I think, in all fairness, been quite critical of the judicial reform process. As I indicated a few moments ago, you said that it has been an endless process and involved much judicial vilification. You have also said that you have witnessed much humiliation and degradation in the process. Have you witnessed any of this in the process of the selection commission that you're appearing before today, or are these other institutions of judicial reform to which you're referring?
In this, no. I cannot say that I'm talking only about when the check is not about some serious questions. When your relatives acquire some expensive property, like parents who are retired, parents-in-law who are retired, obtain some property in Konchazaspa. But when I'm being asked about my parents-in-law house somewhere in the rural area of Chernihiv region, which was built when I and my wife were 3 years old, this village house, I do not know which check and we'll be talking about, but you are not asking these questions. And I was asked which funds were used to buy or constructed, just like about the apartment of my father, who got it during the Soviet times while working the radio factory. It was a one-room apartment in the old panel house, and that apartment was sold 15 years ago. But you have not asked these questions.
Well, but we have asked questions like that on many occasions. We've asked questions about parents and spouses and children. How else can we learn about questions of corruption and abusive abuse of expenditures by candidates who are applying for appointment by this commission. These are necessary questions. Are you not going to ask any questions of that sort if you are appointed to the HQCJ? Nothing about the spouse, nothing about the children, nothing about friends and acquaintances, nothing about parents. Are those inappropriate questions?
It is necessary to ask, but just like you asked, when there are some significant amounts which do not correspond to the income, or either with respect to the size or the amount, when we are talking not about some village house, but when we are talking about some village resident suddenly acquiring expensive property in the middle of Kiev or some expensive vehicles. But to ask, for example, my father-in-law bought vehicles Labuta, I will not go into ask such questions. Or I will not ask about some house in a village. So the essence of the corruption check is about the check of income. No, about the check of property that does not correspond to the income. Some expensive, posh, middle class property, but not about some ordinary property that is quite understandable. For example, what I mean, my parents have one real estate object where they live. They do not have anything else. Just like my father-in-law, he has one house where they live and they have nothing else, one ordinary vehicle. And I also have one apartment and one car. I do not, I'm reading about judges with the car parks of which Arabic sheikhs can be jealous. Then there are questions when we are talking about such situations, on when we are talking about 10, 15, or 3, 4 apartments even. But each family has an ordinary real estate object and each ordinary vehicle. I do not see how we can see corruption in that. Sorry, maybe you will disagree with me, but that's my opinion.
I mean, you answer that question well in the last few moments, but we do need to know about declarations made properly and valuations that are made accurately. And the only way we can learn about those is to ask questions. Should it be better that we not ask these questions in open and public hearings like this? Is that perhaps the solution?
No, why? That's a public position. People should understand that there should be transparency, especially when there are some real questions and some real discrepancies, or at least the ones that give such a perception. If they give a perception, then I see no problem with asking that. Again, going back to this, I've honestly answered all of your questions. At least I've answered them. Those questions that the selection commission asked to me. And I was also answering questions asked by the ethics council. I was answering them because I saw real questions on the essence, on the merits that can help establish some facts, and I was answering them.
So to summarize, you've not seen any humiliation and degradation and vilification by this commission over the months and years that it's been in existence?
No. On the contrary, I believe that your approach is the best from the perspective of positive approach. It gives more opportunities to get more candidates who will be willing to get this position. And the more choice you have, the higher is the chance to choose the best.
Thank you very much, Judge Kushner. Thank you, Judge Zarzechny.
Yes, thank you, Stephen. I'll now turn the floor over to my colleague, Judge or Mr. Broekhuizen.
Only Mr. Hello, Mr. Kushner. I would appreciate
Hello.
if you could talk a bit slower, because I sometimes have difficulty to understand the translator. And I understand, because of course, I don't listen to your Ukrainian, but I understand that you speak very fast, and that means that the translator is also translating very fast. And I'm not a native speaking Englishman, so maybe I missed something. So if please a bit slow, and I would also appreciate if you keep your answer concise, if that can be. The first thing when I was looking at your profile and your recommendation letter and your biography, I saw that you were retiring when you were 42. And in my mind, when I was 42, that is a long time ago now, 24 years ago, I was just starting my career. How is it that you decided to retire? And what did you do the 5 years between retirement and now? So what were your activities and what did you do? How did you keep yourself busy?
The first question is, I started my career when I was 21 years old, when I joined the prosecutor's office, because I went to school early, then I went to university early. And that's why my career in the prosecutor's office started when I was 21. And I became a judge when I was either 26 or 27. So it happened that, yes, at 42, I had over 20 years of my career. How I kept myself busy? I was doing what I didn't have time to do when I was working as a judge. First of all, I was reading. Legal literature, among others, on different topics. I tried to improve my English. I was learning French. I was doing sports. At the beginning of the full-scale invasion, I had severe COVID instance. I was overcoming consequences of that for 2-3 years. These are the main activities. And sports. I was doing sports as well. With the beginning of the war, given that I'm unfit for service, I tried to join the army several times, but since my health condition was not suitable, after all, I joined this voluntary defense formation. And these are my main activities.
But the activity, the defense in Kiev where you're working, that's, I believe, for 1 or 2 evenings a week, isn't it? Or is that more?
No, not that often.
Okay. No. So the question that arises is, you are in a country that is at war, a very difficult position, and you retire when you're 42, which is quite comfortable. You get quite a large salary as retired judge, and you do reading and sporting. Well, I'm a foreigner, but if I look at that, I think, is this a way, if you're an ambitious guy, to spend your life?
Again, you've correctly pointed out that I participated in the competitions twice. And as you know, each competition takes a lot of time. You cannot apply to each competition. And the competition for the position of the member of the High Council of Justice was also interrupted by the start of the full-scale invasion. So my interview was appointed for March 4, and the war started on February 24.
But if I'm critical, and I'm sorry that I'm asking nasty questions, do you feel that you have been using your life well enough, taking into consideration the fact that the country is at war?
As I've said, I've tried to join the armed forces of Ukraine. I went to the territorial recruitment center twice. I sent my CV several times to military units, but because of my health condition, they rejected me. I've tried to do what I could. I have lifetime pension. I donate on a monthly basis to the benefit of the armed forces of Ukraine. I have been donating on a monthly basis since 2014, and I continue doing that. So I do everything that I can to do. What other options are there? As I've said, I participated in the competition, but if competitions last up to 1 year, what else should I do during this period of time when the competition is ongoing? Should I apply to all competitions at the same time? And you've asked the question about that as well. Besides, as I thought for 2-3 years, I was unable to do anything after, because I was recovering after COVID, and I had problems with my heart, and I recovered on the last year.
Yeah, but you're well now. You're recovered.
Yes, but physically for 2-3 years, I was applying to the army when I had some improvements, but then I had problems with just physical endurance even.
Yeah. When I read your motivation letter, and I'm sorry if I'm asking questions I should not be asking. We have a saying in the Netherlands, there is no stupid question. And that means that, and we have also another saying, any idiot can ask 1,000 questions. And I'm a bit in the middle, I fear. But what I say is there is no stupid question. Eh? When I read your motivation letter, it seems that you're not so much in favor of the way judges nowadays are being selected. There's too many questions, it's too difficult. And what I noted down, if I'm correct, that you answered, I believe, Stephen's question, that you found that you withdrew at a certain moment from the competition because you found that you were asked questions that should not be asked. Are you prepared to ask questions that should not be asked, in your view?
If they are important for the understanding of motivation of the person and their professional experience and personality, personal competences, professional experience, and integrity, then yes, of course, it's worthwhile to ask these questions if these questions will allow getting answers to them.
Yeah, but you did say that you certain questions you didn't want to ask because you suggested that those questions would not be suitable questions. The point is, however, that I've experienced now in the 4 years I'm in commissions in Ukraine, that there is an issue in the judiciary that is connected with corruption, isn't there?
Of course. I have nothing against the corruption questions. I'm talking about questions that show no corruption, that do not concern the corruption at all.
What do you know about corruption? Because I've been working corruption for a long time. And I can tell you that someone who is corrupt may behave as your neighbor and be as nice as anything. He may be nice to his dog. But you cannot see from the outside whether he is, as he has accepted money. And you cannot see from the outside whether the house of the father was indeed his house or was paid by money that was given to the son. So how are you going to decide which is a good question or a bad question if you don't know that?
I do not quite understand what I do not know. I was talking about amounts, about scopes, about class of property that can show about some corruption, about dates of acquisition. That what I meant. That questions about property which emerged when I was a judge, yes, these are valid questions. But if this property was bought when I was a child, how can it be related to corruption? That's what I meant.
Okay. Well, if you, of course, you will know, you know that in the Supreme Court there has been an issue of corruption with the former president of the Supreme Court. And would you be willing to ask to candidates who work or want to work in the Supreme Court quite tough questions about corruption? Or would you accept that someone who would apply to the Supreme Court would be, let's say, without suspicion that he or she has done something wrong? Would you be prepared to ask nasty questions to people who apply for high jobs in Ukraine?
Of course, I'm ready, because I believe that when questions contain justified suspicion of corruption, all of them will be tough. It's not a question of love. That's a question that will be tough, and all of them will be nasty. Like while holding the position, where did you acquire the property, or where did your parents acquire this property? All of them will be nasty. Like if I were not ready, I would not apply. All questions will be like that. No other questions can be there just by default.
Yeah. Well, that is a relief. I would say that you're prepared to ask all the questions. You have not been working as a judge for the last 5 years. You explained also in this interview that you believe that you have experience. If I'm a bit cynical about that, is that you have no experience for the last 5 years because you didn't work as a judge. Why do you believe that you know enough of judiciary and the developments in the judiciary to ask, to review the people properly and to ask the proper questions?
Because all the time I read news, I read different sites of all key judiciary sources. All the time I also read digest of the Supreme Court, which are issued all the time, of the Grand Chamber, of the Cassation Court. So mainly I read digest of my Commercial Court Cassation. And now there are also some other sources, for example, of the European Court of Justice and other international courts. So everything which is related to me in terms of court doctrine. So I read it all the time because it's interesting for me, at least just because it's interesting for me, but also because I read everything which is related to my jurisdiction.
Okay. But there are many people in Ukraine who read everything. That doesn't qualify you to be a member of the HQCJ, I would say. What we are looking for is someone who has specific knowledge from inside of the judiciary. And recently you don't have that, do you?
I have the knowledge which I take from mass media, specialized journals, websites, and other sources from the Supreme Court, for example, and my Cassation Court.
Yeah. And please tell me, are you reading mainly, let's say, court decisions, case law, legal developments, or what do you read?
Yeah, so digests, as I say, and all news related to judiciary system, and I read them on judicial sources of information. So digests have not only court decisions, they also publish all recent news related to developments in the judicial system. So some reports, statistical data, information, presentations. For example, the recent statistics regarding vacancies. Just yesterday, I've read this information, and I read information provided by the HQCJ chair in the School of Judges. That's that statistic which I just yesterday found out, and I look for this information all the time.
Okay. in the HQCJ, you don't, let's say, practice law. What you do, you select people. You're an HR guy, someone who selects candidates. You have any knowledge of selecting people?
Specifically selecting people and as a HR experience, no, I don't have. I have only legal and judicial experience. I don't have any background in HR. I have never worked in the HR field.
Did you, let's say, during your reading exercises, read something also in preparation of your application for the HQCJ about selecting judges and the difficulty in selecting judges for Ukraine?
Yeah, I read also about it. I read also the I visit the website of the HQCJ and I read the information about the competition. I read information about statistical data, what questions are asked. I also read information about this. So if this information, of course, is publicly available.
Yeah, but do you understand that I'm a bit critical by the idea that we would like we should select someone who is 5 years out of the judiciary and who has no experience or knowledge of selecting people to become a member of the HQCJ?
Yeah, that's fully your discretion. I don't object it.
No. The question was, do you understand what I'm critical about?
Yeah, I fully understand.
And can you explain me then why I'm wrong? Why you should be selected?
You know, in my introductory words and my motivation letter, I clearly explained that that's about my previous experience and what I'm reading. I read right now how I maintain my level of knowledge and my level of information. That I read information about statistics, about the course or the progress of the competition procedure. This is what shall help you to choose me.
Okay, I pass the floor back to our chairman. Thank you, Mr. Kushner.
Thank you, Robert.
Thank you. Thank you for your questions. Very good
I
questions.
think, Judge Kushner, you are have been well addressed and given the opportunity, I think, to answer many questions that we have already. You wouldn't be surprised that most of the questions that we do have for you have probably been asked already. I have a second round of questions that I'm going to canvass our colleagues about, but let me begin by asking you basically to explain for me one or two things that may be a problem in legal translation as opposed to fact. And question 7 of our application for appointment, the question is asked, please provide information confirming that if you are appointed as a member of the HQCJ, you will not have any other paid employment, perform any other paid work, receive any other financial remuneration, or any other income. And in part, your answer was, if I am appointed as a member of the HQCJ, I will not have any other paid job, perform any other paid work, receive any other financial remuneration or other income. Now, as I say, this may be a translation problem or not, but if you are appointed to the High Qualification Commission, you will receive the salary, of course, of a member of the commission, but you will also continue to receive other income, and that, of course, is your retirement income. Is that not correct?
As far as I know, that yeah.
All right, as I say, in your answer to that question, you said,
But that's a social benefit. So as I interpreted your question as an income, and the pension, that's a social benefit. That's not an income received from any professional activities or from any work performed. I meant that I'm not going to do any paid work. So that's how I interpreted the question that I received from you.
all right, I understand that answer, and I accept that answer. I think that is a question of interpretation, and other income, as I understood it, was any other income, but I think you provided a proper explanation. I don't want to belabor this point with respect to your decision to retire from the Supreme Court. However, again, we asked you some questions about that. And among other things, we had question number 4 that we gave you just last week. And it said, what was the determining factor for your decision to resign as a Supreme Court judge in 2020? And your answer in part was, and it begins as follows, the endless judicial reforms and the relentless vilification of judges. That is what you gave as the reasons for your decision to resign as a Supreme Court judge. Now, I have been working in Ukraine for the last 12 years with the judiciary and judicial institutions. I couldn't agree with you more that part of the recent culture, and I'm sure it is to assist Ukraine in establishing their application for admission to the European Union, that judicial reforms were an essential part of that process and the process of, if you like, addressing issues of corruption, not just in society, but as well all institutions of society. We have had many judicial reforms. The new high anti-corruption courts have been created. The Supreme Court that you applied to and worked with was an extraordinary example of judicial reforms with respect to the structure, the fundamental structure of the Ukrainian courts. Our High Qualification Commission was completely disbanded and terminated in 2018-19. And of course, our job now has been to assist the High Council of Justice in appointing the new High Qualification Commission. All of these were seen as necessary reforms. They all existed when you applied to the Supreme Court. They all existed while you were working at the Supreme Court. Those reforms were active. One thing that we have to have as judges and persons who participate in judicial institutions is a thick skin, as it is called. You can't be oversensitive to change or oversensitive, as you put it, to vilification of judges. All of us, most of us have been judges, are judges. We understand there will be public criticism of the judiciary. That is what you will continue to face as a member of the High Qualification Commission. That too has been criticized to the point where the entire commission was terminated. What do you say about whether or not you are prepared to accept these conditions as part of the conditions under which you will work if you are appointed a member of the HQCJ. Do you have a thick skin?
Of course. So those reasons which I mentioned why actually retired, and that's actually what happened with HQCJ when HQCJ was dissoluted. So it was also, it stopped functioning before the elections, and yeah, it will continue. And regarding oversensitivity, yeah, if you're absolutely right mentioning it during this time, during this period of my, you know, non-working, non-employment, I had this time to reboot myself, to be more calm regarding critics and not to be overcharmed. You know, now the situation with the Supreme Court taught me that I need just to do my work calmly, not to be charmed too much, and to look at critics as something constructive. So to look at the constructive critics, to use it for something good. If it's not a constructive critics, then I shall not pay attention to it. And those reforms, and I'm fully sure that critics in Ukraine will not end. It will continue to be.
Yes, we can certainly agree on that point, Mr. Kushner. Judge Verlanov, do you have any further questions?
Mr. Igor, tell me, please, what would you change in the work of HQCJ in order to make this work more efficient, both in terms of timing and in terms of assessment, in order to make this assessment more qualitative? What would you suggest to change? Or are you satisfied with the process itself, which is now happening? You know, in this situation, it's hard to suggest something new because HQCJ is so overloaded. As I have read in one of the articles of one of the HQCJ members, he calculated timing, how much time is needed for one candidate, how many candidates for this position do they have, and how many working days per week. And based on these calculations, perspectives are not that great. So we need to understand that at least we need 2-3 hours to discuss one candidate. You cannot change it. Statistics-wise, it's also how many of them will get negative opinions and how many will be forwarded to the plenary session of the HQCJ. So you cannot change it. And how many days you need to read materials or participate in the discussions. You cannot change it. You shall also have some time for reading materials, reading files, and participate in sessions. But what I liked the most, that's like know-how, that they divided this competition procedure for appellate courts into 3 stages. I've just recently read a very good book of this Scrum founder. That's actually the method of work which was founded by him. So he suggested to focus at final results, cascade graphs, and so on, that it doesn't work actually. And his new methodology, completely state-of-the-art methodology, actually suggests that all work shall be divided into very short-term periods. And at the end of each short-term stage or period, you shall look at this interim results of the stage and then tailor your next stages based on these interim results. That's why I think that it's a good approach to have 3 stages for competitions for appellate courts. It will help because you cannot cover with 1 stage all the competitions for appellate courts. But then maybe in a quarter, in 3 months, they will have some interim results and they will manage to submit some candidates for HCJ for some courts. courts in some regions, and in such a way they will close at least those 5 courts. So those 5 courts will start working. Then they will move to the next stage, to other courts, because if that's a long-term process without any interim stages, it will not end in any good manner. And also just recently, there was another information of another court member saying that there was critical situation in the Carpathy region, and they reach out to HQCJ that they need to help that, and like giving a such a hint that all those 17 judges should stay there. That's his what he says. I think that the HQCJ approach to appellate courts competitions is a very good example of giving at least interim results. But anyway, this will be results, because as I have mentioned, for example, the statement of Usik, the chairman of HQCJ, if we close all appellate courts, if we have no interim stages, then it could last till 2026 or 2027, and there will be no results before it. So I understand you. So do you support this this approach? Yeah, completely. I completely support this approach. Thank you. Ted, over to you. I don't have any other questions.
Yes, thank you. Any further questions, Stephen?
I do have one more question, Judge. Judge Kushner, again, thank you for your participation today, and you've been approached with many difficult
you.
questions. I'd like to ask you one more question about one more word in your motivation. You have been a judge, and you know how words matter. They matter in the courtroom, they matter in your opinions, they matter in your orders, they matter in everything you do. Words matter. And I'd like to ask you again about a word that's been raised several times. It's endless. You will be, if you're appointed by this commission, a member of the HQCJ. You will be choosing the best of the best to serve as judges in Ukraine. You will be looking for the most honest judges possessing the greatest integrity. You will be looking to identify judges who have hidden conflicts of interest and hidden scandals. I'd like to know how you would reduce the endless process as you sit on the HQCJ. When I hear you talk about the word endless, maybe I'm wrong, but it suggests to me impatience. It suggests to me that you might be a force for shortcuts and diminished scrutiny of candidates on the bench. Please persuade me that I misunderstand what you mean by endless. That is a concern that I have, and I'd ask you to summarize your concerns about an endless process one more time, and how that would define your work on the HQCJ if you were appointed. Thank you, Judge Kushner.
Thank you. I mean that cases should not only be read, cases have to be analyzed. We need to analyze all information in order to find some discrepancies. Discrepancies between property and income. You have to calculate and encounter which income the person had and which property the person has, how much it costs, how much was declared, as now we see from situations. Like, for example, the elite car, but it is declared at the price of a vehicle from some, which is old and cheap. So for that, it is necessary to establish how much this car can cost. And for that, we have analysis. We identify whether the declared prices, declared costs correspond to the real situation.
Judge, I'm proud of the people that we've put on the HQCJ. I'm proud of the decisions that we've made, but it's taken us nearly 4 years to do that. It's taken us 4 years because we want to transform the judiciary of Ukraine. We want to make Ukraine more we're going to make it more possible for Ukraine's judiciary to equal that of European countries so that it can enter the European Union if it chooses to do so. But it's taken us 4 years. What should we have done to expedite this process and to make it a less endless process, in your opinion? What should we have done to have made this a much more shortened process by maintaining this, while maintaining the same standards that we've tried to apply?
I think that probably it's impossible to expedite that, no matter whether we want it or not, but this is a lengthy process. And first of all, it is takes a while to collect all information. It is impossible to do that in one day. Plus special check, it also takes a lot of time, and it takes more than 1 day. And how to expedite all of that, it's difficult for me to imagine how it can be expedited. The matter is that many people think that everything can be put into one basket: quality, quantity, and speed. But in reality, these are contradicting factors. You either have quantity or quality. It is difficult to find the balance. The higher the number is, the worse the quality will be, because then you're overloaded with work objectively. If you're trying to do something quicker, then again, you might have problems with quality again, because speed does not contribute to thorough analysis and thorough study. And here you always have to look for balance between quantity, quality, and speed. But I've always been the supporter that quality should be the priority. To expedite and to get a quicker result, I think it's not appropriate if quality is compromised.
I guess I would just agree with my colleague, Mr. Burkhuizen, that we've learned about misdoings by applicants. We've learned about shortcomings that they have only by asking questions that may be viewed as embarrassing, difficult questions. Often they've answered and they've persuaded us there were no problems. Other times they haven't answered as well. So it's only been with tough questions, difficult questions, embarrassing questions that we've learned about our candidates as best as we can, and ended up putting the best of the best in our judgments on the HQCJ. And of course, that's what we'd like to do this week as well. Thank you again. Thank you again, Judge Kushner. Appreciate your time and your responses.
Yes.
Thank you for your questions.
Yeah, thank you, Stephen. I should just observe, of course, that unfortunately, during the work of our commission, Ukraine was subject to the invasion of the Russian military, and that certainly contributed significantly to the suspension of our operations and the delay as well. And I know you know that, Mr. Kushner. Any further questions, Robert?
Yes. Well, maybe it's more a remark, and I would appreciate if you could reflect on my remark. Let's say that you are proposed by us and elected by the HCJ. What I would be worried about is that from, let's say, doing nothing much to a very, very busy job, because I know it is in the HQCJ. I know the people, and they work really day and night to do their work. They are responsible people, they work hard. And it comes with large responsibility. And that means that we need someone who is intelligent enough to do the work, and I'm sure you are, because you clearly have very good brains, but also is willing to stay for the full period and work to the benefit of the country and the judiciary for 4 years, day and night, and perform as good as you can. How can we be certain that you will not quit after 1 year or 2 years, or withdraw your application or whatever?
I see no reason to withdraw the last moment. I I do not know how to comment on that. It's just like how to give the guarantees, but the way you are talking about working day and night, I'm not scared by that. As I mentioned, during the first year and a half in the Supreme Court, when we were dealing with Romanian cases, every other weekend I was spending at work. I did not work during some weekends only because I needed some rest. But every other weekend, I was working full Saturday and Sunday because I was always drafting motivation of my decisions on my own. I never delegated this task to my assistants. They could make some references from the case law, from the laws, but the conclusions were written always by me. So that's why, in order to do that in a timely manner and with quality, and in order not to cause any delays, I stayed and worked until late evening. We had days, as you're properly saying, when back then I was renting an apartment close to the court building. I woke up at 6 a.m., went to work, and I was coming back when I finished my work. I could stay until 11 p.m. And sometimes we had court hearings until 1 a.m. during the first year. Even the court hearings, not only to read and write. So I had this experience and it cannot surprise me. Working till late night and working during weekends is not new for me.
Thank you, Mr. Kushner. Back to our president, Ted.
Thank you, Robert. Mr. Kushner.
Thank you
Yes,
for your question.
Mr. Kushner, we've certainly spent a good amount of time with you this afternoon and early evening, and we've certainly, I hope, given you an opportunity to answer the questions that we have presented to you. This is now time, Mr. Kushner, for your final remarks to our commission. Please feel free to let us know now your final conclusions about the process and about your candidacy. The floor is yours.
I'm sincerely grateful to you for the opportunity provided to me. I've tried to answer all questions honestly and objectively as much as I could. I hope that I've answered all of your questions. I do not know whether they will satisfy you or not, but I've done my best. I have no other questions. Thank you so much for questions, especially for tough questions and for Mr. Roberts' questions. I'm not afraid of tough questions. I believe that any discussion should be heated and tough when we are talking about this position. Otherwise, it's meaningless. It's huge responsibility, and this is a very responsible position in order to have some mild or not tough questions. Otherwise, all of that would be meaningless. So I'm grateful to you. I hope that I have provided exhaustive answers to your questions. Whether they will satisfy you or not, that's for you to decide. But I hope that at least I've provided exhaustive answers. Thank you.
Thank you, Mr. Kushner. And on behalf of the commission members, I thank you for your application for this appointment. We will certainly seriously consider all of the information that we have with respect to the 4 candidates we will be interviewing. And we thank you for your participation in this process. With that, Victor, if we could now close the meeting, please.
Good evening, dear colleagues. The Competition Commission for HQCJ continues its work. We have an interview with our next candidate, Victoria Anatolyevna Holub. Greetings, Madam Victoria. Good evening. The Commission is present here in the following composition. I am Ivan Mishchenko and my colleagues Sergei Varlanov, Ted Zazhechny, Stephen Markman, Robert Berghuisen. Yevgen Mezentsev does not participate in this interview because he's your former colleague, and based on this precondition, Yevgen has submitted his self-recusal from this interview. The procedure of this interview will look the following. I will introduce you very concisely, and then you will have an opportunity to tell about your motivation. Why actually decided to apply for this position in this competition? Why would you like to be a member of the HQCJ? And afterwards, after your presentation, our commission members will ask you some questions. And if we have enough time, we'll have 2 rounds of questions. Each commission member will ask you so many questions as they have. And at the end of our interview, you will also have an opportunity for your final words, where you will be able to wrap up or maybe to say something what would have not been mentioned during the interview in your replies to our questions. So we have interpretation. That's why, please take it into consideration when you are speaking. So our candidate, Victoria Anatolyevna Holub, she was born in Makiyevka in the Donetsk region since 2010. So since 2010 till now, Victoria is a judge of Donetsk District Administrative Court. She's married and she has a son. So, Madam Victoria, please tell us, and maybe our audience who is watching us right now, why did you make this decision to participate in this competition? As far as I understand, that's your second attempt. No, the third attempt. Even third attempt.
Yes, Mr. Chairman, I'm sorry to interrupt. Just wish to report that Judge Yevgen Mezentsev has recused himself from consideration of this candidate because of a professional acquaintance with her.
Yes, thank you, Ted. I've mentioned that as well, but thank you. We had some technical delay. I'm sorry for that. There was some problem with the sound. Okay, Madam Victoria, please. The floor is yours. Good evening, dear members of the Selection Commission. Good evening, dear viewers of the broadcast. I would like to introduce myself. I'm Victoria Holub. I'm the judge of Donetsk District Administrative Court. At once, I would like to say that my professional experience in the position of the judge is 15.5 years, and for 23 years, I've worked in the judiciary. At once, I would like to move on to my motivation. Why have I decided to take part in this competition? The matter is that in 2019, I submitted documents for participation in the competition for vacant position of the judge of the Court of Appeal. But that competition did not take place because authorities of the former composition of the HQCJ were terminated. That's why when in January of 2023, it was announced that there would be a competition for positions of the new composition of the HQCJ, I decided to take part in it. First of all, it was interesting for me to find out how the selection process would take place. Secondly, I really wanted to not to be a viewer from the outside, but I wanted to directly take part in that. With respect to that, I would also like to tell you a few words about my strengths that will be valuable if I am appointed to the position of the member of the High Qualification Commission of Judges of Ukraine. First of all, that is experience. As I've mentioned, I've been working as a judge for a long period of time, and I've worked in the judiciary for a long time. I held all positions that exist in the judiciary system, starting from the secretary of a court hearing and ending with the position of the advisor of the president of the Court of Appeal of Donetsk region. Also, I believe that this experience will helps me to understand everything that is happening in the court and to build relations with my assistant and secretary of the court hearing, because I understand what is happening. I was in their shoes in the past. Some other strengths that I would like to mention include the desire to have continuous self-improvement and training. I support the idea of ongoing training. I want to improve both of my personal and professional skills and qualities. I really like the saying of the wise man Andrei Voron, who was 104 years old, who said it to the book to Miroslav Dujin. He said that a stone that is moving will never be covered by moss. I fully share this opinion. And thirdly, that is hardworking. While working in the judiciary for a long period of time, there were different times with respect to the workload. There were periods when on a daily basis, we received cases in boxes. I cannot even mention the number of specific number of these cases that we received. And why I believe that this quality will be of use. 3 weeks ago, I was interviewed by the new composition on the HQCJ, and I saw how they work. The interview started at 10 a.m. and the day ended almost at 10 p.m. But I'm not afraid of that. Then I would like to say about responsibility and decisiveness. Judges almost every day take decisions. And that's why decisiveness and responsibility are one of the key qualities. Also, I would like to point out requirements regarding my own integrity, first of all. I believe that the moral right to assess integrity of other people is given only to those people who have integrity. And also, I would like to emphasize the capacity to make correct conclusions. As I've said, this is my third time when I'm applying for participation in this competition. And when I did not succeed for the first time, I asked myself a very correct question. What was lacking in my case in order to get to the list of 64 candidates who were interviewed? And since then, my transformation has started. And another quality that I would like to mention is persistence. So I'm not ready to give up upon the first failure. Thank you for your attention. And if necessary, I can additionally explain any questions that you have regarding this. Thank you, Madam Victoria. I will start, if you don't mind. I will start the session of questions and answers. My first question is obvious. This is your third time when you're applying for this competition. It means that you have a serious desire to become a member of the High Qualification Commission of Judges of Ukraine. Can you please tell us very briefly, in 3 sentences, why? Why? First of all, I see how important it is to restore trust in the judiciary of Ukraine. There is a demand for that, both inside Ukraine and from abroad. And I'm doing everything possible at my current position. I started having social media in order to cover and to show to people how I live. I show my life in the social media. And secondly, I thought that work as a member of the HQCJ is very similar to work of the judge. That's also about analysis of documents. That's about work with inspector and assistant. That's and to be able to join the process of selection of judges who have integrity to do something important and interesting with my life. For me, that's the best motivation. Okay, clear. Thank you. Madam Victoria, in your motivation letter, you mentioned that members of the HQCJ, which is working now, introduced new standards. Which standards do you mean here? May I follow up your question? Do you mean about the new composition? Yes, yes. What I've noticed in the work of the new composition is absolute openness. I have not seen anything like that in any of the composition. And I really like the work that is being done by the current member of the HQCJ, Sergei Mak, when he is communicating and covering all the news that are happening in the HQCJ. He is answering questions of the candidates. So I support transparency, openness in this regard. For me, this is really a good practice, and I would love to continue that. Okay, clear, thank you. I have the following question. Please do not consider that as criticism. I'm really curious about your position. I think that after the second competition or the first competition, I do not remember for sure, you published a blog where you described your experience of participating in the competition. The mood of this publication was quite critical. The essence of this criticism, if I understand correctly, consisted in the fact that you did not quite understand the reasons why the selection commission did not invite you to the interview. At the same time, this commission and I personally follow the so-called positive approach. The essence of this approach is that we do not prepare negative decisions. We do not have them, contrary to other commissions. And if due to some reasons, this commission believes that the candidates currently maybe is not ready, then the commission just thanks to him or her for participation, and then the commission continues working with other candidates, which in the opinion of the commission are more, have higher chances to be selected and to add value to the work of the HQCJ. After all, in your opinion, going back to that publication that you had and having now this experience, would you like to get the negative decision from the commission? Or the format that the commission has now is, after all, in my personal conviction, it is more suitable. That's a question that is open for discussion. There is no right or wrong answer. And I'm not asking you to praise our commission, because other commissions follow other approaches. And in their opinion, it's absolutely reasonable to apply some negative decisions. And in fact, this is a very controversial issue. So in your personal opinion, after all, what model is better? If we evaluate this positive approach, I believe that it has two sides. The first is the positive one. Candidates do not get these negative decisions after the competition. And the competition can be held during a short period of time. So if the person has received a negative conclusion, then this person may challenge the negative decision, and it may take a while. But in my opinion, there is such negative aspect of this positive approach, which consists in the fact that the person who fails to be admitted to the next stage does not understand what happened. I'm just telling about my experience, why I had questions, because the commission highlighted those documents, those events, and what the commission analyzed within the framework of the competition. And it mentioned that it received 600 explanations from 301 candidates back then. And I understood that since I was not asked to provide explanations, because explanations are being asked when something causes doubts. So I thought that if I received no questions, then automatically everything was fine. Somehow I did not even think that I might not be suitable. So that's why I had this question emerging, why I did not provide explanations back then, and I was not included into the list of the 64 candidates admitted to the interview. But if we are talking in general about the positive and negative approach to the selection, you've explained to me now the essence of this approach and what happened back then. So after all, I support the positive approach. Okay, my last follow-up question is the following. Continuing this idea, let's imagine that you are selected as the member of the HQCJ. And let's imagine that the HQCJ has the possibility to influence the legislature and adopt the model that would be the most suitable for the HQCJ. For example, from the perspective of selection to courts of the first instance. So if we are talking about selection of judges to the courts of the first instance, like lawyers, specialists who have never worked as a judge, in your opinion, what would be more appropriate, to use the positive approach or to use this model with this negative decision to explain to people why the HQCJ took the decision not to admit them or to terminate their participation in the competition? Which model, in your opinion, is better in practical work? Which model would you choose? Please. I support transparency and clearness of decisions. And I believe that people have the right to know what was wrong, why they got the rejection, why it happened like that. And people have the right to prove that they're right, including the court proceedings. And the positive approach in selection is, again, I'm just expressing my opinion. It leaves aftertaste of something not being fully said. It's not clear what happened, why it happened like that. For example, for me, if I got the negative decision, maybe it would be more clear for me in which direction I should improve myself. I would not challenge the decision. I would just understand that I need to improve something in me in order to succeed next time. You know, it's not clear what happened. And a person is sort of aside. And I think that it is necessary to adopt decisions for transparency, clearness, so that the candidates wouldn't know what happened and why they were rejected. Thank you. Thank you for your answers. And I'm passing the floor to my colleague, Ted Zajechny.
Yes, Judge Holub, thank you for coming to this interview stage. I'm going to deal a little bit with some property issues because, quite frankly, I had some difficulty following you and your husband's acquisition and sale of a number of properties, and particularly difficulty understanding your right to purchase a new apartment in Kiev under construction and the circumstances surrounding that, which was somewhat criticized by one of the newspapers and the articles that was brought to our attention. But let me understand firstly. You indicated to us in response to some of our questions sent to you some week ago or so that you were displaced, of course, the uh, from the area that you had been working because of the Russian invasion. And you indicated that between 2014 and 2018, which is at least some 3 years, perhaps 3.5 years, you did not have any residence, but you were, as you have it interpreted by our interpretation service, living with relatives and friends on the terms of utility payments. And therefore, you did not declare the right of use of those properties in your judge's declarations. Now, so far, do I understand your circumstances correctly as it relates to this issue? All right. Well,
Yes, you're right.
good. At least we're together to begin with. Now, I understand as well that during that period of time, you applied for and obtained dislocated housing assistance. Is that correct?
I was receiving tailored support, tailored benefits, and during the period so before actually we purchased an apartment in the city of Kharkiv. As soon as we purchased that apartment back in 2021 in the city of Kharkiv, so next day I submitted an application and rejected receiving of this benefit. Till that moment, our family hadn't had any property in ownership on the territories which are not occupied. And the law says that the tailored benefit is provided only to those who have no real estate objects in their ownership. So before October 2021, we haven't had any real estate objects, I mean apartments or houses in our ownership on the territories which are not occupied.
All right, and I understand that and accept that explanation. the point that I am uncertain about is that during that period of time, when you did not pay for any housing, you nevertheless applied for and received displaced persons allowance and financial support. Is that correct?
Yes, that's correct.
All right.
As
And-
this, so actually it envisaged payments for utilities. So it covered utility payments.
And
I received it for myself and for my minor child.
I see, and not for your husband?
No,
All right. And during this period of time that you received the public assistance, you and your husband were already working as judges of the court, were they not? Were you not?
yes, we were working as judges.
And from the information I received from 2015 to 2017, you received a salary of between 367,000 and 437,000 hryvnia per year. And in 2018, that was increased to 749,752 hryvnia, and in 2019, 1,639,000 hryvnia. And then in 2020, 2,072,000 hryvnia. Now, you, during some of that period of time, 2014 to 2018, you had no property, you had no rights to use any property, you lived at property owned by friends or relatives, and you paid only utilities, and yet you applied for and received a housing allowance. So with that income and in those circumstances, you applied for and received a housing allowance. Is that correct?
Yes,
Now, do you think that that was a right thing to do with the income that you were receiving?
the issue is that judicial salary was increased only during the recent years. And at those times when we were receiving those salaries, I mean from 2014 to 2017, that salary was not on the same level as we are receiving right now. And we were also IDPs, I mean internally displaced people, as other Ukrainians. I didn't see any illegal actions in my in what I did. So I declared those payments in my declarations, and when the full-scale invasion started back in 2022, I stopped receiving this benefit, even in spite of the fact that I was entitled to get it, because I saw the scale of the tragedy, the scale of what is happening, because so many families need this support so much. That's why I stopped receiving this benefit, and I stopped submitting my application to receive this benefit. And since 2014, yes, indeed, we had been receiving it. I don't think that I violated any of the rules, any of the norms of legislation.
So did I understand you to say that you terminated the public assistance in 2022?
In 2021, so when we purchased an apartment in the city of Kharkiv, so you in the beginning you mentioned the apartment in Kiev. No, not in Kiev, apartment in Kharkiv. So 2021 we purchased apartment in Kharkiv, and next day I rejected receiving this benefit, and then I didn't submit any other applications to receive this benefit again.
Right, and that was in 2022 that you terminated?
No, 2021. 2021.
I see. But up until that time in 2019, you and your husband received over 1,600,000 hryvnia. In 2020, you received over 2 million hryvnia as salary. And in 2021, 2,400,000 hryvnia. And it was not until after that that you terminated the public assistance you were receiving.
I can explain it. So what was happening during those years? In 2019, my husband, and with my approval, notary approval, he purchased property rights for the apartment that should have been built in the city of Kyiv. So it means that everything, all salary which my husband was receiving, we transferred to this construction place, to this purchase. So this payment should have been done during 2 years. So all salaries which my husband had been receiving, we actually transferred for this purchase. And my salary was spent on household issues and some living expenditures. That's why, because of such expenditures, yes, indeed, I didn't stop receiving those benefits, public benefits.
Yes, well, my point is that you continued to receive that assistance while you were making a very significant salary between you and your husband, and you had no expenses other than utilities. Is that correct? Or am I misunderstanding something?
So we started receiving increased salary. I don't remember the specific year, but in 2014, 15, 16, you mentioned the level of salary. We didn't receive that increased salary. It was 300,000 of hryvnia per year. And those millions which you mentioned just now, those millions we have received a salary in 2019, 20s, and 2021. And half of it we paid for to pay for this one bedroom apartment in the city of Kyiv, which should have been constructed, and for the other half of our salaries, yes, we lived on it. So yeah, you're right in this part.
All right. I have another area about questions respecting property. You say that in 20 before you were appointed a judge, you received money from your mother, and from that, you purchased 3 apartments. Your mother, for 7 years, you tell us, was working in, was it Cyprus? Yes. And she was working as a cleaner of a house, of houses. Now, the information we received with respect to her incomes, perhaps while she was working in Cyprus, but perhaps when she was still working in Ukraine, indicates that she received a very low level of salary. And the question that I have, when she was working and living in Cyprus, and she was working as a house cleaner, she would have had her own living expenses that she had to pay. Where would she have gotten the money to give you sufficient funds to buy 3 separate apartments?
My mom was working in had been working in Cyprus since 1998. Yes, since 1998, roughly till 2005. At that moment, one-bedroom apartment in Donetsk didn't cost that much. And I wanted to underline also, yes, that these are three one-bedroom apartments, and the residential area of those apartments is 12 square meters, 18 square meters, and 17 square meters. So not the total area, but the residential area of each of those apartments, 12, 18, and 17. So she lived in the same house where she was cleaning. So it means that she didn't spend any money for accommodation or for food. All was covered by her hosts. Once per year, I visited her and she gave me those money.
And what was the idea behind buying the 3 apartments? And what happened to those apartments?
So the idea was the following. I was living in Donetsk, so I'm myself from Makiivka settlement. But when I started studying at the Donetsk National University, I didn't have any property in Donetsk, and I rented that property. That's why the first one-bedroom apartment, which we purchased, I was living there. Then we purchased the second apartment, and then the third apartment, my mom was living there. It was located one floor lower than the second apartment. So why we wanted to purchase that third apartment? Because she has a minimum level of pension, and there is no actual international agreement between Ukraine and Cyprus. And even despite of the fact that she was officially employed in Cyprus and she paid all her taxes, she didn't receive. It was not counted. Those years of work in Cyprus were not counted into her working period. That's why she wanted to purchase that apartment and to give it for rent. But since 2014, the Donetsk is being occupied. Now I don't have any access to those apartments. I can't sell them as an owner. I can't give them in any way. So they are registered at my name, but I can't dispose them. I can't use them.
All right. I'm going to end my questions for the time being there. And I return the chair to you, Mr. Chairman.
So let's move on. Sergey, over to you for your questions. Madam Victoria, I will continue follow-up questions regarding property to follow up those questions which Ted asked you. So the Commission has also some questions to you, and we are kind of asking you to explain. Did you and your husband receive any income from selling property rights for the apartment in the city of Kyiv back in 2021? Yes, I received. Yeah, so you answered that yes. Then, can you please explain why you failed to declare it, that income that you received? I will explain it right now. So the issue is that when we received that income from selling the property rights for a one-bedroom apartment in the city of Kyiv, my husband submitted a report to the NACP where he indicated the sum and the change of the property status. As we did it for the first time, I mean such selling of the property rights, I looked for the information in the internet where I should submit such information. And I found out that only that family member who is the owner of those property rights shall submit this information and and who actually carried out the selling agreement. And that's why I thought that, yeah, my husband informed the NACP and I don't need to do anything else. In the declaration for 2021, we declared the sold apartment and another apartment which were purchased in the city of Kharkiv. The issue is that I think that the difference in timing was just 1 week. So we sold property rights for apartment in Kyiv, and in a week we purchased another property. That's why when I fill in property sections in declarations, I always look for information from tax inspections, and I always consult with accounting department at our work. So I correspond all those data, all those figures received from tax inspection and from my place of work. So I indicated in my declaration all those figures, which were the same. So mm, I I I didn't know at all that I need to additionally indicate the sum in the yearly declaration, because according to the law on the status of judges, judges actually are prohibited from receiving any type of income from scientific, scholar, creative work. That's why I thought that we reported to the NACP that we have received those money. We didn't hide those money. We declared them. We declared that property immediately. Both properties, the one which we sold in Kyiv and the one which we purchased in Kharkiv. And I realized that I need to additionally indicate this income in the declaration later. But look, Madam Victoria, your husband is a family member and you receive income for a family. And that's why you're obliged to do it, to declare it according to the provisions of the law. But you explain it that as he declared it as a subject of declaration, that you don't need to do it. Yeah. Was it the only income that you received as family? No. What were the other incomes? Did you declare them? Or no, I didn't declare. So in 2021, we had such two cases because my husband sold a vehicle and immediately purchased another vehicle. So that's the only car, the only vehicle which we use in our family. And so the case with selling a vehicle and buying a new one, and the case with selling an apartment and purchasing a new one. So these were two cases back in 2021. Good, I've got a point. And afterwards, when such questions were raised, I was thinking, I was reflecting, and indeed I realized that this declaration, serves as the balance sheet for enterprises. There should be credit and debit. I need to show what is the source of funds for purchasing apartment in the city of Kharkiv. But I explained to you what were my reasons not to declare it. Good, thank you, dear Victoria. I will follow up some questions of Ivan, which he asked you at the beginning of the interview. So explaining your strengths and your strong sides, why actually you and not other candidates should become an HQCJ member. So you told us that you think that the trust to the judiciary should be restored. And giving as an example, you mentioned that what you do, you actually cover in different social networks all the things which happen in the system itself. What else would you like to explain? What else is needed in order to restore the trust to the judiciary? What do you think? What else should be done? Give us, please, more specific examples.
In order to restore trust in the judiciary, in my opinion, now I'm thinking from the perspective of the HQCJ. After all, it is necessary to complete selection of judges in order to fill in all of those vacant positions, because having excessive workload, judges do not have enough time to consider all the cases. So that's why we have many cases which are considered with a violation of the term for their consideration. Of course, all parties that have a delay in terms of their decision are not happy about that. So that's just one side of the coin that I would like to mention, and to how I see the restoration of trust. Okay, tell me please, Madam Victoria, can you provide specific examples from your professional achievements? Taking into account that you've mentioned that your strength is your experience of work that is quite significant. Can you please provide some examples of your professional achievements? I believe that my professional achievements include, first of all, the absence of complaints from the parties. I've never been subject to any disciplinary proceeding. and there are no separate rulings regarding my decisions. For me, this is the main indicator. That's regarding, in my opinion, if I were analyzing candidates of judges, I would pay attention to that. Because if there is a complaint, it is necessary to clarify why the complaint has been filed. People just do not randomly submit complaints. Secondly, I try to improve my professional skills all the time. For example, in 2023, I entered Nicholas Romeris University in Lithuania to learn and to understand more about the process of mediation. I believe that for a judge who is taking decisions on a daily basis, and I understand which of the parties will be dissatisfied, to have the skills of mediators. And besides, the procedural codes now envisioned the settlement of the dispute by means of mediation when the decision is adopted through compromise. And both parties in this case are satisfied, and then this decision is being enforced. And I believe that mediation has a promising future, and that's why I've entered the university, and I have no regrets about that. Thank you, Madam Victoria. I'm passing the floor to Mr. Ivan, chairman of our commission. Thank you, Sergey.
I believe so.
So I'm passing the floor to my colleague, Stephen. Stephen, please.
Judge Holub, thank you for coming today, and thank you for your participation in this competition. I think it's to your credit that you were faithful to your oath as a Ukrainian judge when you relocated, I think in 2014, in response to the Russian occupation of Donetsk. I think you lived up to your responsibilities in doing that. And I also found one of your statements and your motivation to be very thoughtful. One of the better statements I've seen about the role of the judge in my experience over the years. You said every case has a human fate behind it. I don't know if that's your own statement or it came from somewhere else, but I think it's a very well put, very intelligent statement. No case is routine to the parties in the case. And that statement seems to suggest that you appreciate that. And I give you credit for that. Let me raise some concerns on the other hand, if you don't mind, please. You've shared many thoughts with the commission, several ideas that are kind of unorthodox and unusual. You are involved in blogging. You have indicated some interest in you and your husband being engaged in competitions for judicial and judicial positions. You would like more reasons why you were not chosen in your competitions. And you've written articles defending your blogging on sites that some Ukrainians may find controversial, including the Judicial and Legal Newsletter, which has been described by at least one person I've heard, not everyone, but one person who says that it is an anti-reform and anti-Western site. I don't know that, I haven't seen it personally, but some have described it that way, and you have put your article on that site. My concern is, are these indicative of a serious-minded jurist? I want a jurist on the HQCJ who is thinking at all hours of the day about how we are going to put the most highly qualified judges in Ukraine on the bench so that they can transform the judiciary of Ukraine. I'm not interested in these things that may call attention to yourself, and they seem to have that in common. Will you please tell me why I'm wrong in this assessment? I want people in the HQCJ who have nothing more important to do with their day than to find the best qualified judges they can to transform the judiciary of your great country. And I'm concerned that you seem to be more focused upon things that draw attention to yourself.
May I answer?
Please.
The matter is that I had several publications. I do not quite understand from your question which article you are referring to in particular. But if we talk about my publications in general, they raise issues. In my opinion, they show that I'm not indifferent. I'm not indifferent to the judiciary, that I'm not indifferent to what is happening. In my opinion, I very correctly state my opinions. I think about each word in order not to insult anyone. I'm just highlighting how it is. And 3 articles, I cannot say that I'm publishing them on every day and that I dedicate attention to that all the time. When I have such a desire, then I publish something. But whether it indicates that my lack of seriousness, in my opinion, no. It's just previously, when I worked in the 90s, since 2023, the judiciary was closed in the past, but I believe that it's better for people and it's more clear for people where they understand the system and when the system is open for them.
Do you think that that site, that website, is fairly described as anti-reform and anti-Western? I don't know that it is or isn't, but do you think it's fairly described in that way?
Can you repeat, please, your question? I did not hear the last sentence.
Do you think that the website in which you've published judicial and legal newspaper is fairly described as an anti-reform, anti-judicial reform, and anti-Western website?
I do not consider this website to be anti-Western. And on the contrary, I think that they are very neutral in their presentation of information, including both legal and what is happening in the world. I have not seen any judgments there. So that's why I'm referring to them, because I read their news and I like how they present the news. I think that they are very neutral, just like facts.
Are you pro-judicial reform?
Yes, yes. I support the judicial reform, but I think that in order to reform it, we need to fill in vacant positions of judges in order to be able to talk about anything. Because right now, judges work in extremely difficult situations. They work almost round the clock, and that's why to talk about reforming right now when there are vacant positions in the court, when one judge works in the court, and we have such courts with only one judge sitting on the bench. And to reform them, I think right now we need to focus all of our efforts on filling in vacant positions.
What will your priorities be on the HQCJ if you're placed upon that body? How will you make the judiciary of Ukraine better and strengthen the judiciary of your country?
Right now, as I see, the selection commission has the task to choose the best 16 member of the HQCJ. But it is one thing when you were selecting the full composition, and the other thing is when you are selecting the 16th member. This is a formed body with only one position being vacant. And as I see it, the new members should join the work of the commission. The commission has worked for 2 years now, and these new members should work everything possible to achieve the result. As I see, there are now announced competitions already. There are ongoing competitive selections to fill in the vacant positions. For example, now they have announced the competition for the position for 1,800 positions of judges in the first instance court. And my suggestion, I would like to speed up this process so that we would be on time, because the commission has 2 years left in this composition. I would like to speed up the process of the conduct of the competition. And one of my suggestions is to have online testing. I mean, testing for the knowledge of Ukrainian statehood, for the knowledge of law, to have this testing online so that candidates could take this test at home. First of all, it will be useful because we over 9,000 applicants have applied for the competition. And if this testing is undertaken by 60 applicants at once, the process of testing can take years. And secondly, it will help candidates save money, because going to Kyiv means rent of housing, tickets, nutrition. Maybe for some of them, it would be an excessive burden. And online testing, as I know, it can be done. It's possible to put such time in that a person would have no opportunity to cheat. So if the person knows the answer, then the person gives the answer. If no, then the person will not have time. I did that. When I was studying in Lithuania, we were taking some exams online from home, and I understand that this system is effective, because if you do not know the test, then you will not pass it. And I think it would be one of the effective measures that could speed up the process of conduct of this competition. And then interviews should be held offline, of course.
And Judge Holub, you have emphasized several times in your motivation, more than once, that you want to appoint ordinary people to the judiciary. Do you disagree with me that maybe the better idea would be to appoint extraordinary people to the judiciary who are possessed with the highest standards of integrity and fair-mindedness and understanding of the law? How do you resolve this debate between the ordinary people and the best of the best, the extraordinary people? Is there something the judiciary needs more than ordinariness?
Ordinary, I do not understand what you mean by ordinary, but
I think it's
I
your
do
word.
not.
I think it's your word that has been translated to us in that way. Okay, well, maybe we'll put the interpreters.
I do not divide people into ordinary and extraordinary. For me, the main criterion is for the person to be having integrity and competent.
Well,
And
you
to divide people.
You say something else about ordinary people. You say judicial institutions are usually assessed by people who have never gone to court, what I would call ordinary people, most of whom have never gone to court. Then you continue to say that is why their assessment is not always true. Can only those people who have been involved in litigation offer a fair opinion of the judiciary, not those who are just members of the public, who are dependent upon their courts for safety, security, and the rule of law? Why do you think that only people who've been to court can offer thoughts on the progress and need for improvement of the judicial branch?
I wrote that because I think that the person who has participated in the court hearing has experience.
So the criminal who's in
experience.
court can offer the comments, but the ordinary law-abiding citizen shouldn't be offering their own thoughts.
Comments can be given by anyone, but the matter is how objective they are. That's the question. How can they be supported?
Why do you assume that somebody who's won or lost in the court can be objective? I would think that maybe they'd be just the opposite of objective. They think well of the court when they win, and they think poorly of the court when they lose.
I agree with this statement. Yes, indeed. I meant that a person who has participated in the court hearing has experience and understand what is happening inside the judiciary. So this person can point out something. But when the person has never had any experience with the court system and starts criticizing it, then in my opinion, in this case, it's not objective.
Let me ask you a final question summarizing my first concern. You call attention to a number of interesting ideas, but I don't find those very useful to the development of the HQCJ as the best possible judicial selection body that it can be. Can I be assured that you are going to spend your time on identifying the best of the best judges in Ukraine, and you're not going to be spending your time on blogs and shows about you and your husband competing for things? Can I be assured of that with your appointment?
Yes, you can be assured of that.
Thank you. Thank you, Judge Holub, and thank you, Judge Mashenko.
Yes, I'm always last. I don't know why. Hello, Miss Holub. Maybe I call you Julia, no? Victoria. Victoria, that's it. Sorry. Sorry. Of course, I read the website Stephen was referring to every day, which contains quite useful information about the development of the judiciary. And in that respect, I also read a few years ago a comment about our commission that you made, where you even mentioned, I was very proud of that, my name. Thank you for that. It makes me very famous in Ukraine because everyone read it. And you were complaining that, that you were not selected, and you were wondering why this was. And of course, I've been thinking about the question why you were not selected the first time and why you are now. And there is my first question to you. The last time you also had to send in a motivation letter, didn't you? This time you have, and the time when you applied and you were not selected, you had to write a motivation letter as well. It's correct, huh?
Each time I needed to submit the same package of documents for participation in competition, yes.
But am I right if I think that you have written your motivation letter different this time than last time?
Again, can you repeat your question, please? Please be louder.
Am I correct to think that this time you wrote your motivation letter different from the first time that you applied?
Yes, yeah, I updated my motivation letter Because 3 years have passed and some of my ideas were already not on the table, not appropriate.
But maybe it's also true that you answered the question whether there are any specifics that you may need to tell the commission that you didn't do last time, but you did do this time.
Yeah, I would be happy to tell you my position and my thoughts regarding maybe some ideas, you know. So first of all, I would look at the experience of the previous composition of the commission, because the period for work for HQCJ members is only 4 years. And I think that it's not long period of time, and we don't need to waste this time for lessons learned, for finding out something new. We need to
But
to
that's
use the
not what
previous
I mean.
experience.
This is not what I mean. What I try to ask you is that the letter contains a question 4 and a question 5. And the question to you is, I will read you to the question. Please provide information related to specific situations, blah, 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 that may raise concerns about your candidacy to the selection panel. And it's the first question 4. The number 5 is, please provide information that relates to specific issues that may give rise to concerns about your declared income. And I see that in the motivation letter you sent now to us, you have specified quite a number of issues. And my question is, did you do the same the first time?
If I'm not mistaken, that in this part, nothing has changed. It's the same.
Are you sure?
Do you see any discrepancies in
No,
this
because
part?
I don't have the first letter anymore, because all the information has been taken out. But what I would expect is that when we were reading your letter the first time, we noted there were a few discrepancies and they were not mentioned. And that was a reason to take out people. And now it's all listed.
Can I answer?
Sure.
The issue is that from the perspective of what has happened during the last 3 years, I would never even imagine that I would be grateful that you have not paid attention to my candidacy last time. It was because it was actually a great impetus for me to review what I'm missing, what I'm lacking, in order to improve my situation and to achieve this level of interview. Because that Victoria in the past and this Victoria, which I am now, that's a huge difference. And I think that now I have more chances to be in the list of winners in comparison with my chances at that time. So I'm so grateful to you for this opportunity.
Okay. Did you ask access to your file before you have had this interview?
What do you mean? What do you mean under access to my file? I didn't get your question.
You are able, if you want to look at the information that we have about you as well. Did you look at this information?
No, I didn't look. I didn't know about this opportunity.
Okay. Well, there's in the file, there's quite a substantial report of a CSO about you, about all kinds of properties. And I think that my colleagues have been asking questions about that, a few questions about that. And it's quite a list with issues. And the reason we are here, of course, is to discuss with candidates those issues. You understand that, huh?
Yeah, of course, of course. I'm happy to answer all your questions.
Okay. And in your motivation letter, you answered the question why you applied. Yes?
Yes.
And then you say something like that you want to implement new standards in ensuring transparency and openness of the selection process. That's what you write in my English translation. You say the main motivation for participating in the competition to select a candidate for the position of member of the HQCJ is the desire to be involved in a team of professionals who implement new standards in ensuring transparency and openness of the selection process. The goal is to maximize approximation to European standards of judicial proceedings. What I find funny about those sentences, if I understand them, there is no mention at all what is the reason for all what we are doing. And that is that there are apparently issues of corruption in the judiciary. You didn't say anything in the motivation letter about this aspect, and corruption in the judiciary is a very serious issue if you want to become part of the EU. And the reason for that is that the EU doesn't want to give endless amount of money to Ukraine if it ends in the wrong pockets. Simple as it is. So your job is, as part of the HQ, if you are part of the HQCJ, to avoid that money ends in the wrong pockets and that corrupt judges are hired. What are you going to do about that?
During, can I specify your question? So do you ask me what I'm going to do during selection of candidates for positions of judges, specifically in this dimension, is the dimension of the anti-corruption?
No. I know what the HQCJ do. What I ask you is that I read in your motivation letter that you want to maximize the possibility to enter the EU and use EU norms for your judiciary. That's what you say. Yes? And I say to you, this has mainly to do
it says
with,
like this.
this is mainly to do with corruption. And my question to you is, what are you going to do about it?
Do you mean corruption? Do you see any corruption signs in my desire? I understand that I can't ask you the questions, but I can't connect my desire to join the European standards in the judiciary system and connect it with the corruption. So if I may, if I can understand, if I understood correctly, the question of Roberts, and in your motivation letter, you don't mention corruption in the judiciary as a key problem. And you say that we need to integrate into the European Union, and that's the right way, it's the right thing. And the key obstacle for our integration, that's the issue of corruption in the judiciary system. And the European Union has repeatedly mentioned it to us. So, what are you going? What are your positions on it, on that matter? What are you going as a potential HQCJ member? to do it? How are you going to handle this problem? Yeah, I'm not going to object and deny saying that there is no corruption at all in Ukraine as a notion. No, if the situation would have been like this, then maybe members of the anti-corruption court, judges anti-corruption court would be left without job. But Ukraine is doing all the possible to overcome this problem. Recently, we have established relevant anti-corruption authorities. We have anti-corruption court. You cannot wake up once in the morning and there is no corruption when it was last night. No, that's a process we need to go through. I think that the issue of overcoming of the corruption is the work, and you shall show your own example, showing zero tolerance to corruption for people to have no desire, no at all to do any corruption acts. So you always shall start with yourselves. Otherwise, in terms of selection of candidates, we shall pay attention to candidates. HQCJ members have so much information which they study, which they research, including property issues. And I'm sure that these attentions are under scrutiny from the side of HQCJ members.
Mr. Chairman, the translation is difficult to follow, and there's also a connection problem. So I couldn't gather everything that has been said, but I think I get some of it.
I will gladly repeat, Mr. Robert, if there were problems with connection. I see that this is an important issue for you, so I will gladly repeat if you want.
Maybe short.
I would like to say that, yes, really, in Ukraine, we have such a phenomenon as corruption. But Ukraine is on the pathway towards decreasing and overcoming it. And this is proven by activities implemented by many anti-corruption bodies. We also have functioning high anti-corruption court that is considering cases all the time. These cases are not hidden. On the contrary, we have disclosure and public discussion of such events and violations. And I believe that it is impossible to overcome corruption in a day, no matter how much we would want it. So like, it's impossible to have a corruption yesterday and not today. But first of all, we should display a zero tolerance through our personal example, so that a person who has some...
Okay, but I did not want to discuss with you corruption in general. I wanted to discuss with you corruption in the judiciary. And the question to you was, if you are a member of the HQCJ, what are you going to do about it to avoid that corrupt judges are appointed?
I will thoroughly study all the documents that will be available in the judicial dossier or in the candidate's dossier. Moreover, I believe that as an option, it's possible to suggest to create a portal so that people could send messages or some statements, not anonymous, but to sign them with respect to the candidates, if there are some facts of previous corruption instances, to study the past of the person, to study the financial situation. And you're asking the great question about corruption, and it's a good experience that can also be used in the future in order to establish whether the person is prone to corruption or not.
Okay. Thank you for your answer. Back to the chairman, please.
I think that we will try to have a second round of questions now. Madam Victoria, I will have very brief questions. In continuation of Robert's question, I understand that's a complicated question that it's difficult to answer right now, but we have the HQCJ, we have the PIC, and we have, in addition to the Public Integrity Council, we have an entire range of civil society organizations that are monitoring different competitions that are also taking place, including the one to the HQCJ. Do I understand you correctly that you want to create some additional portal, as you've said? One more, like something else? Some other PAC? Do I understand you correctly? No. No, I'm not talking about the PIC. The PIC is the community of people united by their common goal, working to alongside with the High Qualification Commission of Judges, and the PIC helps with the selection of competent judges with integrity. But when I'm talking about the portal, I mean some portal for individuals, legal entities that would have the possibility to send a message directly to the High Qualification Commission of Judges. Not when the judge has been adopted, but before that. Now everything is happening in a transparent way. Everyone sees the surname of the candidates, and I would want them to have the opportunity to directly address the HQCJ if they have some concerns about some candidates. Okay, great. I understand your opinion now. Thank you. Where, in your opinion, should be the boundary, and whether this boundary exists with respect to the privacy of a judge, family, and close persons of the judge? Until when should information be disclosed? I will explain the context of my question. The society demands a lot from judges. At the same time, there is such an idea that not all lawyers and prosecutors want to become judges. Not all of them apply for competitions. And quite often, these highly competent attorneys mention as a reason for their unwillingness to be judges is the fact that it's they should need to disclose too much information. In your opinion, where should this boundary be between publicity and privacy? Or should there be no boundaries at all when we are talking about judges? Or should it be somehow intensified? Maybe it should be done some like harsher. For example, there were ideas to close declarations. I do not think that declarations should be closed. Yes, I agree. I agree with people who are not ready to open up their life in such a way in order to understand the position of the judge. But that's how to properly phrase that. This is the reality of the judge's life and judge's position. And for example, while taking part in the competition, in this particular competition, I'm not concerned with respect to the openness of my declaration. I'm not concerned that we are discussing property issues that I and my family have. I have nothing to hide. That's the choice of the person. If the person is concerned about publicity, then they are not ready. And I see nothing horrible in that. Like, everyone has the right to choose. And I think that these people should not apply if they are not ready to do that. Being a judge, you need to love this job. You need to love people. You need to be ready to listen, to understand that a person does not come to court because this person has great life. And when, for example, they look at property and expensive vehicles, and then they have some questions, complaints emerging, and then I believe that nothing should be closed. If it has been earned, and if a person has earned the money to buy that, then fine. If people are interested in my social media, some follower asked me, how much do you get? My declaration is open. Please look there. I have nothing to hide. I'm not afraid of that. And that is a public job. And that's why I see nothing bad in publicity. There is nothing scary in publicity. And I think that if we close everything, then people will have even more questions. Whenever we support openness and transparency with you, why should we close that? And publicity, if the person is not ready, then that's the choice of this person. Okay, I've heard you. Thank you. Colleagues, do you have any additional questions to Madam Victoria? No. No questions. Okay, then I suggest to bring our interview to the end. Please, Madam Victoria, now you have the opportunity to address the Commission with your concluding remarks. Maybe you would like to say something that was not said during the interview, or maybe you would like to emphasize some ideas. Please, now you have this opportunity. Thank you. Thank you for this opportunity. In my final speech, I would like to emphasize the following. The matter is that the decision to come to this competition is well thought. I believe that I have experienced necessary skills and knowledge in order to hold this position. In case I am selected to this position, I'm open, I'm ready to come to this work with new ideas, and I will work in order to achieve the result. I consider myself in this competition and now to be one of the strongest candidates. But I would like to draw your attention to the other aspect. I'm concerned about what is happening to our country and people right now. It's painful for me. And I believe that the task of everyone right now is, first of all, to survive, and secondly, to withstand. And if it happens like that, then our country will withstand. I believe that evil will always be overcome by the good. And if it happens like that, then we have a long process of recovery of our country. And it's impossible without investments. And investments are possible only in case we have a fair judiciary that will be open and clear, both inside Ukraine and outside of Ukraine. That's why I want to join the process of creation and selection of worthy candidates. And I will do everything possible to achieve that. I will want us to rebuild our country and to create such conditions in our country that all the Ukrainians who are now abroad will come back to Ukraine with happiness. I want to have the situation when our children will never have the situation when they will have to choose where to live. And if they have to choose, I want them to choose their motherland, their beloved Ukraine. And I want this to be their conscious choice, not because borders are closed, but because they have taken this decision. I'm sincerely grateful to you for attention, for this opportunity to express my ideas and to take part in this interview. And lastly, I would like to say glory to Ukraine. Glory to heroes. Thank you, Madam Victoria, for this interview. Thank you, colleagues. Let's finish. Please switch off